Good afternoon, and welcome to the keynote address of our 47th Institute on the Ethics of Journalism. My name is Brian Richardson, and it's my distinct privilege to be teaching our signature journalism ethics course this term in the absence of our Knight Professor of Journalism Ethics, Ed Wasserman, who is taking a richly deserved sabbatical. Before I introduce this evening's distinguished speaker, our own Professor Toni Locy, I'd like to recognize and thank the other professionals who have been so kind to join us for this weekend's seminars. For our visitors, please stand and remain standing as I introduce you until all of you have been named. And for the rest of you, please sit on your hands until I tell you it's time to applaud everyone at once. Going approximately alphabetically, I think, Jennifer Agesta, who happens to be W&L Reed Hall graduate of 2000. She is now polling analyst with the Washington Post. Mike Crittenden, banking and financial policy reporter with Dow Jones Newswires. He's Journalism and Mass Communications 01. Louis Hodges, our Knight Professor of Ethics in Journalism, Emeritus, and the founder of our Journalism Ethics Institutes and these keynote addresses some 35 years ago. Tom Metesky, this term's Reynolds Distinguished Visiting Professor of Journalism at Washington and Lee, and the retired Deputy Bureau Chief with CBS News in Washington. Amy Morris, who is News Director with WDBJ Channel 7 TV in Roanoke. Olympia Miola, who is the politics reporter with the Richmond Times-Dispatch. Lindsay Nair, who is a features reporter with the Roanoke Times. Michelle Washington, who is a staff writer with the Virginian Pilot in Norfolk and a 1994 graduate of the Department of Journalism and Mass Communications. And Bill Whitaker, correspondent with CBS News in Los Angeles. Is that everybody, I think? Okay, please join me in welcoming all of our Institute participants. Thank you. In the interest of time, I am not going to introduce each of them, but I'd also like to acknowledge the students in our journalism ethics course this term, and I'll ask them to stand, if you will, all at once. Students, please. Thank you. I go to conferences of journalists or of people who worry about journalism a couple of times a year, I suppose, although in these parlous times they keep getting canceled. I always come home with ethical challenges in the form of neat freebies. Umbrellas from the Associated Press, tote bags from the Baltimore Sun. Once I even got a scorpion encased in lucite from the Arizona Republic. And some of these are real collector's items now because the newspapers or the newspaper chains they represent no longer exist. But that's another story. My wife continually lobbies me to get people to let up on the tote bags. We've gotten to the point where we are stuffing tote bags into other tote bags as a way to store them. And unfortunately, not even Goodwill appears to want them in these days. Anyway, the other day Francis said to me, you know what you guys don't have for the Ethics Institute that everybody else has? Party favors. You need to talk to Ed Wasserman about party favors. So then she and I had to decide what would be appropriate to give out at an Ethics Institute. She hit on the idea of hair shirts with writing on them. Something like W&L Journalism Ethics Institute, Winter 2009, runner-up, or maybe scourges in W&L colors for honorable mention. Toni Locy began her how's that for a segue? Toni Locy began her distinguished career in journalism about the time my much more checkered life as an ink-stained wretch began running dry. But we have both been around, with apologies, long enough to recall the days when most people in the industry saw journalism ethics as the sort of hair shirt party favor. Ethics was when you beat yourself up after screwing up a story, hurting somebody unnecessarily, usually. You wore the hair shirt for a couple of days, then promised, like all penitents, never to do that again. And then, like all penitents, you do exactly the same thing the next time the opportunity arose, because nobody much was arguing in those days for ethics as a process that you went through before you put something in the paper or on the air. Toni Locy is a walking case study. The walking is always done in high heels. In doing journalism ethics the other way, of thinking deeply and proactively about how to give audiences the information they need while protecting the people who need protecting, about making tough decisions based on our fundamental ethic to inform, about recognizing and accepting the consequences of those times when we decide that our moral obligations trump even the law. A veteran of 25 years covering the American justice system at all levels, Toni joined us this year as Washington and Lee's first Donald W. Reynolds Professor of Legal Reporting. As USA Today's reporter covering the Justice Department in 2001 and 2002, Toni reported on the federal government's efforts to link the 2001 anthrax attacks that killed 5 people with a particular person. Unidentified sources told several reporters, including Toni, that former Army scientist Stephen Hatful was a possible suspect. In 2002, then Attorney General John Ashcroft called Hatfill a person of interest in the investigation, whatever that means. Hatfill sued the government, not Toni or her newspaper, his lawyers contending that Hatfill's reputation had been damaged by the Justice Department leaks. In response to a motion by Hatfill's lawyers, Federal District Judge Reggie B. Walton last year ordered Toni to reveal her sources or pay up to $5,000 a day in fines from her own pocket. 4 days later, a higher court granted a stay while Toni appealed the ruling. The appeals court eventually vacated the lower court order that Hatfill and the government, and after Hatfill and the government settled for $5.8 million. But the troubling issue of mammoth legal fees is still hanging over Toni. I know she's going to talk a little bit about her experience with us today. In the past year, Toni has been recognized by the American Society of Newspaper Editors, been given the Society of Professional Journalists First Amendment Award and the National Press Club's John Aubuchon Freedom of the Press Award, and has met with Capitol Hill staffers to voice her support for a federal shield law pending before Congress that would protect journalists from being compelled to reveal the identities of confidential sources. She has made several other appearances before groups of journalists and lawyers as well, and just this week, she almost got stuck down there, she testified before the Texas legislature on a shield law being considered for that state. In addition to her 5 years at USA Today, Toni has covered the Supreme Court and legal affairs for the Associated Press, federal courts for the Washington Post and the Pittsburgh Press, and criminal justice for the Philadelphia Daily News. She has also worked for the Boston Globe and U.S. News and World Report. She has a master's degree in the studies of law from the University of Pittsburgh School of Law. Toni's professorship is made possible by a grant from the Donald W. Reynolds Foundation, and we are deeply grateful to the foundation. Her lecture, Committing Journalism, Contempt for Reporters in Post-9/11 America, and our Journalism Ethics Institutes are underwritten by the John S. and James L. Knight Foundation. Please join me in welcoming Toni Locy.
Thanks, Brian, for those kind words. When I was covering federal court in Washington, D.C., the chief judge at the time was Tom Hogan, who was the judge who put Judy Miller in jail. And Judge Hogan used to say that he could tell how big the story was by how fast my heels clicked on the marble floors. But throughout my 25-year career as a journalist, I opposed these so-called shield laws because I was uncomfortable with the notion of carving out special treatment for reporters. I thought that as long as I was fair, accurate, and skeptical of government, I would not need any extra legal protection. I thought the First Amendment of the U.S. Constitution and the constitutional protections of the states I worked in would be enough. Unfortunately, my experience with Dr. Stephen Hatfill's Civil Privacy Act lawsuit proved me wrong. In October 2001, I was one of many journalists who reported and wrote about the anthrax-laden letters that were sent through the mail to U.S. senators and media organizations. As you will recall, 5 people died, 17 were sickened, and thousands of other people were forced to take antibiotics. Congress shut down, while activities at the Supreme Court and other government agencies were disrupted by the anthrax threat. The fear in Washington was palpable. I distinctly remember days when FBI agents were summoned from office building to office building to investigate suspicious white substances found on desks, computer keyboards, and on elevator floors. The substances turned out to be nothing more sinister than powdered sugar from donuts, but the anthrax attacks so frightened people that restaurants stopped serving powdered sugar on French toast, and people in small towns called police to open their mail. The anthrax attacks acutely panicked the American public, unlike any other form of terrorism, because everyone felt personally vulnerable to the primary attack mechanism, and that was the U.S. mail. My job at USA Today was to tell the terrified public what the FBI and other government agencies were doing to respond to the anthrax crisis and how well they were doing it. The public wanted to know and needed to know whether the FBI was going to catch the killer or killers, and if investigators were acting adequately and appropriately to protect the public from another attack. Because people desperately wanted to know about investigative activities that are inherently secret in nature, to do my job and inform my readers, I had to rely on a large number of confidential sources. This included about a dozen or so people in the FBI and Maine Justice Department who provided important information to me only on the condition that I keep their identities confidential. I pledged to protect their identities because that was the only way I could gather and report information about the deadly anthrax attacks that my readers wanted to know. The anthrax investigation was not my sole area of responsibility. It was one of many topics I was assigned to cover in the highly charged atmosphere following Al-Qaeda's September 11, 2001 terrorist attacks on this country. As a result, the 2.5 years after the 9/11 attacks were the most intense of my career. I remember no other period in my adult life where the stakes in my reporting were as high on so many subjects. In addition to the anthrax investigation, I had a substantial role in reporting on everything from the FBI's ongoing investigation of the 9/11 hijackers and the hunt for Osama bin Laden, to developments in the criminal case against Zacarias Moussaoui and the impact of the USA Patriot Act. I also covered the habeas corpus challenges filed by detainees held in the Bush administration's war on terrorism and the administration's efforts to create military commissions to try suspected terrorists held at Guantanamo Bay, Cuba. With respect to most, if not all, of those topics, I repeatedly and regularly consulted with confidential sources, including my FBI and Maine Justice Department sources. My practice was to run through a litany of questions about all of my areas of responsibility whenever I had any time whatsoever with my sources. I did not ask solely about anthrax or Stephen Hatfill. Anthrax was on my list of questions, but it was not the only question I posed to my sources. As a result, I cannot match my sources to particular facts at issue in the Hatfill case. Forcing me to disclose all of my sources based on speculation that some of them might be able to remember providing that information to me would have resulted in disclosing confidential sources who had nothing whatsoever to do with the articles at issue. What's worse is that disclosing such sources could pose problems for people who provided me with information for stories on issues that were far more sensitive than the articles I wrote about Dr. Hatfill. I have no notes to refresh my recollection. As a young reporter in my first job at the Pittsburgh Press, I was taught to discard my notes. A media lawyer told us to come up with a system, be consistent about it, and to throw away notes. The advice also had a practical element to it. If I kept every note I took on every story I ever wrote, there would be no room for me in my house or my office. In those days, the early 1980s, the biggest threat we faced as reporters was from prosecutors who issued subpoenas for our notebooks. Such efforts appear almost quaint compared to the threat reporters face today from civil lawsuits such as the one filed by Dr. Hatful. Over the course of my career, I wrote thousands of stories. I was a beat reporter. Everywhere I worked, I usually was one of the most productive members of the reporting staff. Of that large body of work, 2 stories were at issue in Dr. Hatful's civil lawsuit against the Justice Department. They were written in May and June of 2003. They were not scoops. They did not appear on page 1 of the newspaper. As a result, neither story holds a special place in my memory. In fact, both stories were written several months after then Attorney General John Ashcroft went on national television in August of 2002 and publicly labeled Dr. Hatful as a quote-unquote person of interest in the anthrax investigation. I remember my reaction to the Attorney General's statement. I had never heard such a term used in this manner. Suspect, target, focus of an investigation, yes, those were terms I knew. But person of interest, it set off alarms in my head. I asked my sources about it, and they were as baffled as I was. But my sources also were angry that the Attorney General would do such a thing. Imagine this. FBI agents were more concerned about a suspect's rights than lawyers at the Maine Justice Department. I subsequently searched the U.S. Attorney's Manual, which is the federal prosecutor's handbook, to see if I could find any such reference. There was none. I wrote a story saying so. Use of this term person of interest has exploded, as I'm sure you all have noticed. The term is very troubling because law enforcement authorities are not providing any evidentiary basis for its use. In effect, it can be used as a smear tactic while giving the public a false sense of security by suggesting that law enforcement authorities are on the case. I carried my skepticism of the Justice Department's actions with me throughout my coverage of the anthrax investigation. The longer of the 2 stories I wrote, which appeared on May 29, 2003, was a product of that skepticism. The story described how the FBI had Dr. Hatful under 24/7 surveillance and provided my readers with an update on the investigation. It was written after Dr. Hatful had a confrontation on a Georgetown street with FBI surveillance agents who were watching him. Dr. Hatful received a traffic ticket, not the agents, after they allegedly ran over his foot while driving an SUV away from the angry scientist who was upset that his every move was being monitored. My May 29th story explained the incident to my readers, and as I said before, it broke no new ground. It was not a scoop, but it was accurate. And I am proud to say that it treated Dr. Hatful fairly by prominently comparing the FBI's surveillance tactics in his situation to a famous FBI debacle. Richard Jewell, the security guard who came under FBI suspicion in the 1996 bombing at the Olympics in Atlanta. Mr. Jewell was completely innocent and was in fact a hero who noticed an abandoned backpack in a park and cleared the area. One person died when the bomb exploded, but the death toll could have been much higher if Mr. Jewell hadn't acted quickly. As a result, invoking the name of Richard Jewell in any article about the FBI equals one thing and one thing only, and that is skepticism. My May 29th story also pointed out division and disagreement inside the investigation about whether Dr. Hatful should have been the FBI's sole focus. For much of the time I was covering the anthrax investigation, representatives of Dr. Hatful repeatedly and consistently provided information to me about him. Pat Clausen, a friend of Dr. Hatfill's, called me repeatedly. I also had numerous conversations with Tom Conley, one of Dr. Hatfill's lawyers. Mr. Conley and I had several conversations about the investigation and about many of the topics that were later the subject of Dr. Hatfill's Federal Privacy Act claims. These issues included whether police dogs had gone wild or not at a scent at Dr. Hatfill's apartment or his girlfriend's apartment, whether Dr. Hatfill had passed a polygraph, what a finding of evasive on a polygraph really meant, Dr. Hatfill's alleged exaggerations on his resume, what the FBI found during searches of a pond in Frederick, Maryland, among many other issues. Mr. Conley also introduced me to Dr. Hatfill at D.C. Traffic Court, and he ordered an associate of his law firm to send me an advance copy of Dr. Hatfill's lawsuit. At no time did Mr. Conley complain to me about the accuracy or fairness of my coverage of the anthrax investigation. In fact, he was very complimentary of my work and was forced to admit as much in the filings in this case before Federal District Judge Reggie Walton. It is important to understand the role of and need for confidential sources in the news gathering process. Confidential sources are not traitors, as the proponents of more government secrecy want Americans to believe. In post-9/11 America, where secrecy is an epidemic, we need government insiders now more than ever to tell reporters how public officials are using their vast powers. Without their help, the public will never learn about government abuse or corruption. Without Deep Throat, there would have been no Watergate. In my experience, most confidential sources provide reporters with information out of a sense of duty and, yes, even patriotism, because they care about the quality of our government. But reporters must be very careful about relying on confidential sources. We must guard against being used. Reporters must always ask themselves why a source is providing information. It isn't because sources think you're cute, believe me. Once a reporter knows her source's motivation, it is then, and only then, that she can weigh the pros and cons of using that source's information in her story. I can only speak to the policies of the newspapers where I worked, and I know that in the wake of several scandals, Jack Kelly, Jason Blair, and Stephen Glass, reporters who made sources up out of thin air, that newspapers re-examined and strengthened the checks and balances in their newsrooms to control the use of confidential, unnamed sources. I always believed that the reporter who covers the law must be relentless in questioning police, prosecutors, and judges about their use of government's awesome powers to subpoena Americans to testify against each other, to search people's homes, and to eavesdrop on citizens' private email and conversations. But we are not cops. We are reporters, not FBI agents. It was not our job to solve the anthrax attacks or any other crime. We reporters do not have subpoena power. We cannot seek and execute search warrants. We also are not private investigators on retainer with plaintiffs' law firms. What we can and should do is cultivate knowledgeable, honest government officials as confidential sources who provide us with accurate, fair, and as complete information as possible about ongoing investigations. And that is exactly what I did when I reported and wrote about Dr. Stephen Hatfill and the anthrax investigation. I was fair, I was accurate, I was skeptical. I did my job and I did it well. Yet I was found in contempt of court, faced fines of up to $5,000 a day, and was threatened with jail. Judge Walton also took the unusual step of banning anyone, my family, my friends, my former employer, from helping me pay those fines. My students couldn't even hold a bake sale for my benefit. Thankfully, a 3-judge panel of the U.S. Court of Appeals for the D.C. Circuit agreed to stay the fines, and I did not have to wreck my retirement fund to pay them. But much to my disappointment, the judges refused to decide several significant issues I raised in my appeal, after the Justice Department ultimately agreed to pay Dr. Hatfill and his lawyers up to $5.8 million to make the case go away. At Dr. Hatfill's request, the Court of Appeals said my appeal was moot and sidestepped issues that could affect the way journalism is practiced not only in Washington, but in small towns and cities across this country. Those issues include whether reporters can be ordered, as I was, to reveal every source they have in order to allow plaintiffs to conduct fishing expeditions in which they may or may not find the evidence they claim is crucial or not so crucial to their cases. My biggest fear is that Privacy Act lawsuits such as Dr. Hatfill's will be aimed at reporters everywhere. If that happens, reporters won't be able to cover any ongoing investigation, whether it is of government corruption or a notorious crime such as the anthrax attacks or a fatal DUI committed by a public official. In the United States, we hold the FBI accountable now. We don't wait until someone is charged, tried, and convicted. This is the United States, not Great Britain or Canada, where reporters face restrictions on what they can write and when. Here in the United States, we cover crime from start to finish and all points in between. No one, not Dr. Hatfill's lawyers, not Judge Walton, ever told me which paragraph, which sentence, or which word in my stories violated Dr. Hatfill's privacy rights. It seems to me that such a word-by-word, line-by-line analysis should have been conducted first, long before the judge held me in contempt and issued a ruling that threatened the ability of reporters to gather the news. Instead, in my opinion, the law was applied backwards. Judge Walton skipped the analysis and charged ahead with an attack on the principle of a free press, giving little, if any, thought to the consequences. Judge Walton strongly suggested that I should not have written anything at all about Dr. Hatfill, and that any and all stories about Dr. Hatfill violated the Privacy Act. I respectfully disagree, and I respectfully suggest that Judge Walton was employing hindsight, which is always 20/20. He knew before the public that the FBI was abandoning its focus on Dr. Hatfill and investigating another scientist, Dr. Bruce Ivins, who worked at the same U.S. Army lab in Maryland as Dr. Hatfill. Last summer, the Justice Department cleared Dr. Hatfill of any wrongdoing in the anthrax attacks and identified Dr. Ivins, who had killed himself shortly before the announcement, as the main suspect. To correct its grievous error, the Justice Department agreed to pay up to $5.8 million to Dr. Hatfill to settle the Privacy Act lawsuit he had filed. Believe me, I do not like seeing innocent people ruined by overzealous or misguided investigators, or by overzealous and misguided journalists who don't question the information they are being provided by investigating authorities. However, I do not believe that cracking down on the press is the answer. Knee-jerk rulings by judges who want to curb press coverage may protect an individual here and there, but such approaches would do more harm than good. In my years covering courts, I often saw judges work very hard to avoid unnecessary constitutional fights. When the First and Sixth Amendments are pitted against each other, as they were in the Hatfill case, there are usually consequences, significant consequences. Like a hurricane that causes beach erosion when it makes landfall, a collision of these two forces within the Constitution often results in an erosion of rights and the public's ability to learn what its government is doing. The public would be ill-served if journalists made deals with prosecutors and the FBI and waited until a suspect is charged, tried, and convicted before they reported on an investigation. There is too much secrecy in the criminal justice system as it is. Secrecy is the enemy of democracy. It seduces people in power, and it makes it difficult for them to resist the temptation to cover up their abuses and their mistakes. Unfortunately, the only way law enforcement learns from its mistakes is through publicity, and sometimes that doesn't work. The FBI used the same exact surveillance tactics on Dr. Ivins and Dr. Hatfill. If the evidence against Dr. Ivins is reputed, what lesson was learned from Dr. Hatfill's situation? Despite the hell that Dr. Hatfill endured, I shudder to think what could have happened if reporters had not covered the anthrax investigation. What if reporters had made a deal with the FBI and Mr. Ashcroft had kept quiet about naming Dr. Hatfill. Does that mean we would have ignored the press conferences Dr. Hatfill held or the many calls from his lawyers to profess his innocence? Probably. Judge Walton also went so far as to say that no public official should talk to the press. And if his order burned sources of mine who had nothing whatsoever to do with these stories, well, that was just too bad. In his view, they shouldn't have been talking to me about anything anyway, and maybe being burned would teach them a lesson. Again, I respectfully disagree. My response is be careful what you wish for because you might get it. And if you do, remember this: if you give up a right, it is difficult, if not impossible, to get it back. If you punish public officials for talking to the press, you will learn less and less about what your government is doing. What Judge Walton failed to understand or ignored is that Dr. Hatfill's life was not ruined solely because of the press coverage of the FBI's flawed investigation. His life was ruined because the Justice Department sent letters to potential employers that threatened to yank government funding if they hired Dr. Hatfill. There is no way the press could have ignored an investigation into the first biological attack on U.S. soil, or Dr. Hatfill, especially after the Attorney General of the United States had identified him as a focus of that investigation. Had we done so, we all should have been fired. The public deserves to know about the quality of FBI investigations. Unfortunately, the public and the press have fallen for what one of my law professors at the University of Pittsburgh calls the myth of clues. What he means is this: the criminal justice system in this country is messy. Contrary to popular belief, most crimes in America are not solved by good-looking CSIs working in fancy labs or by detectives who suffer from OCD and won't rest until they close their cases. The reality is that most crimes are solved when cops pressure confessions out of suspects. The truth is, American law enforcement agencies are often not as good in reality at solving crime as they are on TV. Criminal investigations are fluid, and cops can and do make mistakes. Reporters need to understand that facts gathered in an investigation can change, and they need to be more vigilant about testing their sources' motives and knowledge in order to separate what I call the pretenders from the people who really know what's going on. That's no easy task, especially in a place like Washington, D.C., where government officials are loath to be considered out of the loop. Reporters must test their sources' knowledge by asking how a source came to know something. Were you in on the interrogation? Were you watching? Did you hear the suspect confess? Or did you read about it in a report or hear about it in a meeting? The reporter who fails to probe the motivations of his or her sources is taking an enormous risk. Although Dr. Hatfill's case was settled, lawsuits like it continue to pose enormous danger to the press because of their very nature. They are civil cases, and that means one thing and one thing only, and that's money. It is important to note that Dr. Hatfill's lawyers did not cite any of my stories as examples of unfair coverage when they initially filed the lawsuit against the Justice Department. It was not until several months later that they added me, a reporter who happened to work for the country's largest circulation newspaper, owned by the nation's largest newspaper chain. There is no doubt, in my mind, that Dr. Hatfill's lawyers dragged me into the case as a third-party witness because they looked at me and heard ka-ching, ka-ching. They wanted to go after the news company with the deepest pockets. There also is no doubt in my mind that Dr. Hatfill's lawyers filed a Privacy Act lawsuit to get around the higher burden of proof they likely would have faced if they had instead filed a libel lawsuit against me and other reporters. In my case, I had truth as a defense to libel. Everything I wrote was true. Dr. Hatfill was the primary focus of one of the largest investigations in FBI history. He can file all the lawsuits he wants, but he cannot change that fact. In a Privacy Act lawsuit, the truth does not matter. And that is why those kinds of cases pose such a grave threat to journalists. And the threat continues. David Ashenfelter, a reporter for the Detroit Free Press, is now facing an eerily similar situation involving a Privacy Act lawsuit filed by a former federal prosecutor who was indicted and acquitted of charges that he behaved unethically in a terrorism case. In 1996, the Privacy Act lawsuit emerged as a potent threat to the news media when the Washington Post, New York Times, LA Times, ABC, and the Associated Press joined the Justice Department in paying Wen-Ho Lee $1.6 million to settle his case and make it go away. Mr. Lee, a Taiwanese-American scientist, had sued the government for violating his Privacy Act rights after charges that he spied for China fell apart. I understand why the media companies settled the Lee case. They did not want their reporters to be forced to identify their sources. Unfortunately, others saw the outcome and they want a similar payday. It was a bad precedent to set. I firmly believe that Judge Walton allowed Dr. Hatfill's lawyers to misuse the Privacy Act lawsuit to drag reporters like me into the case, to force news media companies to join the government in making a large cash settlement with Dr. Hatfill. I am very proud of the fact that I kept USA Today from kicking in any money toward the government's settlement with Dr. Hatfill. Gannett, the owner of USA Today, stayed away from the settlement negotiation table at my request. I did not want my former employer to be a victim of what I consider a blatant attempt at a shakedown. I also do not want USA Today to pay any of Dr. Hatfill's legal bills if his attorneys make good on a threat they made to ask Judge Walton to force me to pay the cost of Dr. Hatfill's fight with me over the identities of my confidential sources. My hope is that Dr. Hatfill and his lawyers take their $5.8 million and ride off into the sunset. If judges continue to allow Privacy Act cases to be used in this way against the news media, I worry that editors and publishers will avoid covering the tough story, the ongoing criminal investigation, out of fear that somewhere down the line a civil lawsuit will be filed and their reporters will be dragged into the case like I was. The misuse of these civil lawsuits occurs at a time of severe financial difficulty for the news business. Newspapers in Philadelphia have filed for bankruptcy. Newspapers in Detroit are not delivering papers every day of the week anymore. And nearly every major newspaper in America has cut back on staffing. No company, not a news company or a company that makes widgets, can be expected to go on business as usual under the threat of the crippling legal costs of representing employees who face what I faced. Journalism, or what's left of it, is in danger of being destroyed out of fear. A free press is a right that makes the United States unique in the world. I cannot believe that Congress or any state legislature wants civil lawsuits to be used as weapons of mass destruction against our free press. It pains me and it scares me that we have reached this juncture. I wish it weren't so. But if the courts, Congress, and state legislatures don't step up, if they don't take action, if something isn't done, we may lose what is precious to us, our freedom to hold our government accountable. Thank you.
Toni will be happy to answer some questions.
Absolutely. Oh, it's working, Bob. Come on, 101. I need some questions. Yes.
Okay. In the 5 years, like you said, when you covered the courts, you opposed the idea of the Shield Law, and only this experience changed your mind. Do you remember specifically when you changed your mind? Was it like the revelation? And also, what do you do with the part of it, why you opposed it, which is that citizens should have a free press right?
That's right. It doesn't belong just us.
But
Yes.
to designate journalists, you know, is problematic.
It is.
It's constitutional. So how do you deal with that?
Well, when I changed my mind is when my lawyers called me and said, do you have any money? And I said, I have retirement money. I can call Chuck, Charles Schwab, where all my money is. And I thought, I guess I can call Chuck and liquidate. And that's when I started to change my mind. I still am not comfortable with it. I'm really not, because the First Amendment belongs to all of us. It doesn't belong only to journalists. And I've told my 101 class that repeatedly. It belongs to all of us. And I don't like the idea of having, a special category. But there are other privileges in the law. There are hundreds of them in some states. You have the spousal privilege. You have the clergy penitent privilege. There are lots and lots of privileges in the law that do set aside, special protection for psychologists, doctors, whatever. That still doesn't help me. I'm not comfortable with it. And when I testified before the Texas legislature earlier this week, I told them I'm not comfortable, but I'm more uncomfortable with what I see as the danger, what we could lose if the news media become more timid. And Gannett, I don't even know how much Gannett has spent on me, because they've paid my legal fees. Judge Walton didn't ban them from doing that. But so they've paid my legal bills, and it's got to be up there. It's definitely six figures, has to be, but I have no idea how much it is. But it's a Washington law firm, so I imagine it's pretty high. But could a little paper in Texas do that? When I was in Texas, there was a situation where, these legal fights that news organizations get into are costly. And there was a gentleman testifying before the Texas legislature with me who, a TV station, they had a problem with a prosecutor down there, and it cost them about $17,000 to $20,000 to fight this fight, and they had to lay off a reporter. It cost them a job. So instead of 5 reporters covering the news in that community, they now have 4, and so that's less news for the public, and that's so I'm more uncomfortable with what could happen. So that's kind of offsetting my discomfort. Yes?
Did you ever enter into any conversation with some of the confidential sources who were trying to figure out what their thoughts? Did it kind of prevent them maybe from being a victim of the press, when they were faced with this sort of, with day-to-day background?
One of the things I had to do, Laura, was I had to, my lawyers made me do this, is I had to call this pool of sources I had to call each and every one of them while this was all pending and ask them, would you give me a waiver? Would you waive my promise of confidentiality? And I'll tell you, those were the worst conversations I've ever had to have in my adult life, because no matter how you sugarcoat it, no matter how I tried to go right down the middle, and no matter how you sugarcoat it, you are asking that source, hey, throw yourself in front of the bus to protect me. And I was very uncomfortable with it, and there were other reporters who were subpoenaed along with me who twisted arms of the sources and said, please, please, please save me, save me. And that made me cringe. And I told my sources, I said, listen, I'm doing this only because they're making me do it. And, if you want to give me a waiver, fine. If you don't, that's fine too. I'll go to the wall. But, and my sources were angry. They were angry because, the interesting thing is that this is the irony of the situation is I am one of the few reporters in Washington who was fair to this man. There was a lot of bad reporting, no doubt about it, a lot of crappy reporting. And I didn't like it. I saw it happening, but there was nothing. I did the best I could from working for the largest newspaper in the country. And my sources looked to me, because I worked at the largest newspaper in the country, well, maybe we can correct some of this
bad stuff out there. And these people talked to me. That was part of their motivation because they were so upset by what they were seeing. They thought it was out of control, and it was. And what happened when John Ashcroft identified him as a person of interest, this thing took on it was amazing. It took on a life of its own, and it was, it was this incredible firestorm. And there were people in my sources who were saying, oh my God, look at this, this is not fair. And if FBI agents are more worried about fairness than people at the Justice Department, things are upside down. And that's what made me even more suspicious. But my sources were upset. They were very upset. And their attitude was, listen, we were trying to do the right thing. Why are we going to be punished for doing the right thing by this man? We were trying to help. Even though there's an investigation going on, we were trying to be responsible. And so now we're going to be hauled before a judge? What's up with that? Listen back. Two of them gave waivers, but they gave waivers to other reporters first because we had some sources in common. Dr. Hatfill's lawyers were kind of ticked off because they wanted me to come up with to give them new ones. They didn't want waivers from people that they already knew about, but I didn't. I didn't give them anybody new. Those folks had already agreed to come forward for other reporters. Yes? I can't hear you. Mm-hmm. I wish I could give you a list of do's and don'ts. It's not there. This is not an exact science. I'm sorry? Yes, it is, and it's something that you get as the more experience you get. You get burned. You learn through experience, and I can tell you a story about a police source I had, and very good source, helped me on a story that I broke in Pittsburgh about an FBI agent who was working undercover who had gone over to the dark side and become a drug dealer. And I broke that story with this source's help. Well, when the case ultimately went to trial, when there were multiple defendants, big drug case, this officer came to the courthouse, and I was covering the trial, and he and I were standing outside the courtroom just talking because the court was on a break, and he kept asking me, well, which one of the defendants is Ronnie Urban? One of the defendants, and I even removed the guy's name. And I said, he's right there, because there was a window in the door of into the courtroom. I said, he's right there, can't you see him? He's right there. I said, he's right behind that guy, and this cop says, no, I don't see him. I said, he's the guy with the beard, and he said, oh, okay. And so, I didn't think anything of it until, court went back into session, and this officer gets called to the witness stand, and the prosecutor asked him, first question is, can you identify the man that you were investigating, Ronnie Urban? And he points to Ronnie Urban. I mean, I goosebumps, all up and down my arms. I thought he should have known what the guy looked like if he were really investigating him. It just didn't sit well with me. So what I did was I called my managing editor, and I said, what do we do? And I learned two important lessons here. One, don't give blind trust to every source, and don't trust your editors either. Because she said, oh, don't say anything. We don't want to have a fuss. Just keep your mouth shut. Would it have made a difference in the trial? I don't know. Probably not. The trial was almost over. It had been an 8-week trial. But it would have caused quite a ruckus, because I'm sure the defense attorneys would have made a big deal out of it. But would it have resulted in a mistrial? I don't know. But I learned an important lesson there that you have to be skeptical of these folks, because they are coming at things from their own perspective. And cops want, they want to look good. They want their departments to look good, as do FBI agents. And I wish there was something that I could give you do's and don'ts, but it's like in your personal lives. You learn who to trust and who not to trust, right? I mean, you get burned by friends. You have to just learn that it's more of asking the right questions and learning how to do that and to trust your instincts. If you start getting creeped out, I mean, really creeped out, the heebie-jeebies about something or someone, trust that instinct. Don't ignore it. Don't ignore it. Because it's telling you, whoa, I better slow down here. I need to check this out more. I need to make one more phone call. Anybody else? Yes.
Can you define for me how things happen with classified information? The concept that someone acts out of a sense of patriotism and passes you something that is classified by, you don't believe that it's classified in the sense that it's going to harm us, but supposedly it is defined to knowingly have a piece of classified information in your possession.
It can be a problem, yes. It depends on what it is. I mean, you look at the Pentagon Papers. I mean, they were classified. You know, and they can, the government can slap that stamp on just about anything, and you are taking a chance when you publish, you know, something that does have that stamp on it. And your hope is that you know, when it's all litigated, that some judge is going to look at that and say that shouldn't have been classified. It's not harmful. But you just weigh it. You have to weigh it and say, okay, is this something that the public should know? And if it is, then it's worth the risk to you personally. But I mean, I had situations, because my expertise is covering law enforcement. I had instances where, you know, FBI agents or federal prosecutors, when I, you know, found something out that they didn't want me to know, they would say, oh, you know, you're going to mess up our investigation, or somebody's going to get killed. And my attitude was, I always went right to the prosecutor, and I said, okay, look me in the eye and tell me somebody will die. And they couldn't do it. They were exaggerating. They were exaggerating. And it's like, listen, I am telling you that I have this story. I'm running it tomorrow. You have time to do whatever it is you need to do to make sure that somebody's safe or whatever. You know, you are on notice. I'm not giving you a week or 10 days or a year. I mean, the New York Times with the NSA surveillance story, the eavesdropping story, I mean, they sat on that for a year before they published. You know, I don't know all the ins and outs of it, but I don't think they had it. And it took them a year to get it. So it just depends. I mean, you have to weigh that. And yes, you are taking a chance. You're taking a chance that you could wind up in jail. You know, but when I started covering federal court, when I was not much older than some of you, I was at the Pittsburgh Press, my first job, and one of the veteran reporters said, you want to cover federal court, huh? And I said, yeah, I'm excited. And he said, well, he says, there's no federal shield law. And I said, oh, okay. I said, what's a shield law? But I knew from the beginning, I knew from the time I was 22, 23 years old, that there was no federal shield law. But I just felt that if I was responsible and fair and accurate and skeptical, that I would be okay. And for almost 25 years I was. Anybody else? Yes, Sam.
You've taken particular issue with the Privacy Act law, like civil case.
Mm-hmm.
Do you think there's any instance in which you would feel comfortable with a judge forcing someone to reveal their sources?
Luckily, I never faced a situation where, say for example, I were covering a death penalty case, and I had gotten information that would, potentially exonerate the person, that this person could be acquitted, that this evidence, that the defendant needed it. That's a situation where I don't know what I'd do, Sam. I mean, I someone's life would literally be at stake, and if I had, information that would help him, get acquitted, or even convicted, I guess, from the prosecutor's standpoint, I don't know what that would be a tough one for me personally, to withhold that information. It would be really tough. But I'm not, and I don't, please don't, I hope I don't make it sound like, I'm one of those reporters who thinks I never have to tell anybody anything, because I don't. I mean, I think that it's a case-by-case kind of thing. But a criminal matter, that's a different ballgame. And that's why I feel comfortable speaking so strongly against the civil lawsuit, because the civil lawsuit's about money. That's it. Let's be honest. Somebody wants to get paid. And just because somebody, I feel bad for Dr. Hatful, there's no doubt about it. But I was doing everything I could to be fair to the man, because I just, when I'd ask my sources, well, what do you have on him? What do you have? Well, his resume is exaggerated. I said, well, for God's sake, that's everybody in Washington, So I just had this, it was just this nagging feeling that there wasn't enough there. So, and I just trusted my instincts, and that's what I suggest all of you do. Yes?
What do you think is the biggest story that is not?
Today, the biggest story. Oh God, there's so many. I think that I do not believe there is anywhere near enough attention being paid to the criminal justice system in this country. That's my area of expertise. It's a mess. I think that there is. I really do believe that there are probably quite a few people in prison who are innocent, but don't have DNA evidence. Not every crime has DNA that you can test, because I do think that there are people who are locked up who didn't do what they were convicted of doing, and not just capital cases. I think I think a lot of other cases, serious felonies. But I think that our criminal justice system is, I think a poor person who gets caught up in it is toast. I also think that another big story is the quality of education. I think that we still haven't done anywhere near a good job, a good enough job of covering education and the problems. And Sandra Day O'Connor was on Jon Stewart the other night. Did anybody see her? And she was great. She was wonderful, and she made a point that, we've spent so much time with No Child Left Behind and all that stuff about math and science and reading, but Americans don't know anything about American history or our government. And she started this website called ourcourts.org. And I went and looked at it. It's actually, she's just getting it started, but I tend to agree with her. And I think it's really scary that we don't know our own history. Because, and I think it's true, those who don't know history are doomed to repeat it. And we are doing it. We do it over and over and over and over again. This country does not do well in a crisis. We make the same mistakes. And it's because no one knows history. Yeah.
In a post-9/11 world, so does that change with a new administration post-9/11? Was the culture of Washington set by is that different, or do you think it is something more important?
I think that it's if there isn't another terrorist attack, God forbid, we'll be looking at the same stuff all over again that we saw with Bush. I do think that I'll believe the transparency when I see it. No pun intended. But to me, I don't care if there's a Democratic president or a Republican president. Power is so seductive, and secrecy is so tempting. And I don't care what political stripe the president has. He needs to be watched. And it's going to be a he for a while. He needs to be watched very, very closely. And his minions especially need to be watched. And to me, it doesn't matter. And for people to think, oh, okay, Bush is gone, things are going to be better, loosen up. We don't know that. We don't know that. And you cannot allow government to be left to its own devices. You just can't. It's dangerous, and you can't trust authority, guys. You have to question authority. There's a difference between being skeptical and being cynical. Big difference. Skepticism is a good thing. So you need to question authority more than you do.